So, what is this webinar going to cover? We're going to look today at the top tips for dealing with cross-border estates from a UK perspective. And I'm going to incorporate a real life case study today showing the law and practicalities of what we're talking about to try and put that into some context. It's a huge topic, so we're really going to be giving an overview today on some of the key UK concepts. We're going to be looking at domicile and residency, succession of assets, inheritance tax and capital gains tax, double taxation, obtaining a UK grant, and also some compliance requirements. And I could talk for an hour on each of those topics, so it really is going to be an overview, but you're more than welcome to get in touch afterwards if you have any questions. So what if there is no will? You have a deceased, sadly, that has died fully or partially intestate, which means that in the UK we would look to the intestacy rules contained in the Administration of Estates Act 1925, and these were varied by the Inheritance and Trustee Powers Act 2014. And these only apply to property that the deceased could have left by will. There is an order of entitlement to such assets contained in Section 46 of the Administration of Estates Act, and this really depends on the family member's relationship to the deceased and whether any closer relatives have survived. So very broadly speaking, your spouse or civil partner has priority, and then children or other descendants, and children can still inherit if you have a spouse alive, depending on the value of the estate, and then parents, siblings, cousins, and so on and so on. If there is a valid will but it doesn't dispose of all the assets, then you'll have a partial intestacy in respect of that part of the estate. And as we'll see a little bit later, the Non-Contentious Probate Rules 1987 will deal with the appointment of your personal representative if there is no will or there is a will, but it doesn't deal with this appointment. And again, there is an order of priority regarding who can fulfill this position. Now, something of key relevance in a cross-border estate is double taxation, because it will often be the case that other countries also have a right to levy taxes on the same asset. And if both the UK and another country charge inheritance tax or the equivalent in that other country, the estate could potentially avoid or reclaim some of the taxes paid through either a double taxation agreement or through the concept of unilateral relief. And you're going to need to, again, liaise with those non-UK lawyers to understand the extent of any taxes they are going to impose. Now, the UK has quite a lot of double taxation agreements in respect of income tax, CGT, etc., but not for IHT. There's a really useful list on gov.uk, and you should firstly check whether one does exist with the relevant jurisdiction and really carefully consider what that says. And if there isn't one, hopefully you can obtain some credit in the UK under the unilateral relief rules contained in Section 159 of the Inheritance Tax Act 1984, although it won't be, well, very rarely be for the full amount of inheritance tax you've paid.